And we are live. This is Coffee with a Lawyer. We are streaming on Facebook, LinkedIn, YouTube, and Twitter. And we have a few guests. I'd like to give Anthony the opportunity to give us an update and a question.
Hey, thanks for having me. Thanks for spending your time today, Justin, and got your name.
Chelsea, my very
Chelsea.
helpful assistant, Chelsea.
And Chelsea. So here's the update. I spoke with a company called WGBH, not PBS, last week. They typically, I guess, provide content for PBS, and they are the company that actually has the life rights in perpetuity for my subject, Marian Anderson, who was one of the first Black opera singers from back in the day that I'm doing a biopic on. So I spoke with them, and they said, "Okay, what is it that you want?" And I said, "Well, ideally, I would like to have a shopping agreement since you're not really doing anything with the biopic. You did the documentary. I would prefer a shopping agreement. If we get, a deal, we'll pay you guys, whatever we agree upon from the deal." And he said, "Okay." And then I said, or we can do a collaboration. If you guys want to get involved, we could collaborate, put our heads together and create a package, and then we can do it that way. All right. And then he said, "Okay, you know what? We're represented by Anonymous Content." I said, "Who?" And he gave me 2 names of managers at Anonymous Content. He said, "You know what? We're going to speak to them first and see where we want to go with this, and then get back to you." But in the back of my mind, I was thinking, could they just decide to do a movie on their own and ditch us, me and my manager partner?
That's a good question, Anthony. And
because we didn't have any money to give them for an options agreement, which could have looked cheap.
Okay.
And I'm professional, so.
Okay. Good question. And there is an issue of jurisdictions. Okay. California and New York have developed court precedent that protects you in this scenario in terms of implied in contract law. And I'll get to that. But you bring up some other good points about a collaboration agreement. I just want to specify what a collaboration agreement is. A collaboration agreement is essentially a partnership agreement. And whenever I hear partnership agreements, there is always yellow flags, if not red flags, because partnership agreements are not very productive. Okay, you can be responsible for the liabilities, the debts, and the wrongdoing of your partner. Okay, I don't suggest going forward with partnership agreements. I'd rather you form an LLC and contract with other writers or producers or consultants. I feel that that is the better way to proceed. Partnership agreement really tends to lead to problems. Okay, so that's what the collaboration agreement. That's your collaboration agreement, co-writer agreement, whatever you want to call it. All right, it's essentially a partnership agreement, and partnership agreements can cause problems. Now, back to your main question about whether they can use the work without compensating you, which is essentially the crux of your question. Am I hearing you right?
Yes.
Okay. So first of all, California and New York have a body of law based on court decisions, which we call implied contract law. And there needs to be certain elements satisfied. And really what it comes down to is that there must be an aura of a business setting. So the more factors that tend to lead to it being a professional business arrangement, the better. Where you pitched it, how you're pitching it, are you using NDAs, non-disclosure agreements? Are you getting things in writing? Are you working with an attorney or other professional teams such as a manager? I think in your scenario, I think you would be protected in implied and contract law. However, that's not the strongest legal theory to proceed on. What would be better is if you had something in writing saying that if they use this work, they would compensate you, because you run the risk of them arguing now, since you have already submitted your concept, your idea, your work. You run the risk of them coming back and saying that, no, we already had an independently created work in production. Okay, that it may be similar, but we didn't steal from you. It was already in the works. So you run that risk, and that's what you want to protect yourself from. It happens all the time. That's why a lot of production companies will not accept unsolicited submissions, or they won't accept a submission without representation, a manager or an agent, because they want that third-party protection so that you cannot come after them and say that you stole their work. They will always come back. If they don't accept your work, they'll say that they'll probably have some template language saying that this does not excuse them if they go forward with something similar, because it may have already been independently created. That's what you want to watch out for, is an independently created work. So you really want, when you submit your work, you want them to confirm that they have nothing already in production that's similar to this. Does that make sense?
Correct.
And I know a lot of times you may not have your contracts or the documents for them to sign in place or ready or drafted and ready to go, but at the very least, you should have an email, a confirmatory memo, a confirming memorandum email. After you speak to them, you should be documenting everything, confirming what you discussed. Just the subject of it should be confirmatory memorandum of our discussion. And it should always have the language that includes, if you use this, I have a reasonable expectation to be compensated. That's how you protect yourself. You have to basically create the document trail. You have to create the evidence.
Okay, great. So I do have an email trail scheduling the meetings and talking about Marian Anderson and the rights. So, okay.
Okay, that's good. Although I still say it's, implied in fact contract, implied contract. It's a difficult theory to go on. You're implying it. It's not the strongest legal argument. It is still an argument. It does give you recourse, but it's not a strong legal argument. So as much as you can, try to get things signed. And I know you probably have heard a lot of professionals say, oh, that's not standard, or that's not industry standard. That's not how we do things. I'm not going to sign an NDA. I don't sign confidentiality agreements. Well, they're blowing smoke. All right. So you have to be, aware of that. It's better if they do sign.
Okay. Yeah, they resisted signing. They maneuvered out of signing, said, I don't have really any protection.
Yes, I would consider that a yellow flag. Okay. If they don't want to sign your NDA, that's already a yellow flag.
Okay.
I think dealing with your NDAs in the entertainment industry is very useful. And I think it's very professional. In that industry, in the entertainment industries, ideas are very valuable. It's a creative industry. Your creative ideas are the most valuable property that you have. It's not necessarily a property, because ideas are as free as the air, according to the law, but you got to make it so that it's protected, because ideas are valuable in the entertainment industries. It's the creative industries. Also, to protect yourself, anything that you have already expressed in a tangible medium, I would register it for copyright protection with the United States Copyright Office. Okay. Remember, the general rule of thumb is whenever you are sharing your work with others, that work should be registered with the Library of Congress for copyright protection. The best way to protect your work is to lock it in your desk drawer and never share it with anyone. But that's not the purpose of why you are creating your works. You want to be able to share it and exploit it and monetize from it. So whenever the rule of thumb is whenever you're sharing it with others, it should be registered for copyright protection. And it could be whatever you have. It doesn't have to be your full script. It could be your treatment. It could be your storyboard. It could be your map, your visual map. Whatever it may be, register it for copyright protection.
Okay, great. I do have an NDA with my manager. I don't have an NDA with WGBH, which I can try to see if I can do.
Well, okay, having an NDA with your manager is kind of counterproductive because you want your manager out there working on your behalf. Okay, so if you're limiting him from sharing your work, he can't really fully represent your interests. So I understand why you have an NDA with your manager, but you're limiting him. You want him out there pitching your work to others. Okay. It's really your manager should have NDAs prepared on your behalf to submit to the people he's contacting. Okay.
But you can, if you give written permission, like he sends me an email, then he says, I want to contact these people with the project. And I say, okay, sure, go ahead. That should be okay, right?
That's fair. Yes.
All right. So that's my challenge right now. I'll be contacting probably by the end of the week to see where they are. And that's it.
Okay, we'll keep checking in. Let me see if anyone else, I don't know. Chelsea, were you looking at if anyone logged on? I don't know. I kind of got distracted here. No.
I have been, and there's no one.
Okay. Well, very good. All right. Well, Anthony, keep checking in, and yeah, take care and take action. And we look forward to being of service.
Yeah, that's it. And still nothing from Amblin. So I'm still trying to get in touch with Spielberg.
Well, let us know if we can do anything to help.
All right, great. Thanks.
All right, Anthony, you have a good rest of your week. Okay. Well, I think we're going to sign off now. So every Monday, 9 a.m. Pacific Standard Time, Coffee with a Lawyer, free webinar. Get your opportunity to ask your legal questions, and we're here to be of service. Take care, take action. Have a good week.